employers monitor or control employees' social media usage? There is so much confusion on this topic from both the employer and the employee side of this question, so we're going to cover a lot today. Check out the caption if you want to fast forward to a specific topic, but whether you're a supervisor, an employee, an HR professional, or a business owner, I'd really encourage you to watch the whole video to improve your understanding of rights and responsibilities when it comes to social media monitoring and control in the workplace. Now remember, laws vary by industry and jurisdiction, and the law can change quickly. This information is shared for general, educational, and informational purposes only, and it should not be relied on for any legal purpose. You absolutely must speak to your own independent legal counsel if you need legal advice or guidance. Let's start with the right to privacy, or whether such a right exists at all. If you're an employee, you should understand that what constitutes your reasonable expectation of privacy is, from a legal perspective, significantly reduced when you're using company-owned devices and networks. Even if you're accessing your personal social media accounts, your employer may monitor usage if it occurs on a work device or during working hours. It might help to reframe your thinking of your privacy rights as a so-called negative right. That is, your employer cannot unreasonably intrude on matters of your personal life, rather than as an affirmative right or positive right to privacy. I'm not saying that ethically this is the way the law should be, but I am telling you that from a state and federal legal perspective, it's overwhelmingly the way the law is. Denial or willful ignorance is not going to change that. If you are using a company-owned laptop, cell phone, computer, iPad, or whatever other company-owned device, you should expect that the company has a legal right to track your usage of it, and you should act accordingly. Now, in workplaces that allow employees to use personal devices for work under a bring your own device or BYOD policy, you as the employee should still be cautious. Whether it's a laptop or a mobile phone or otherwise, even if you own it, your employer may nevertheless have some rights to monitor work-related communications or data stored on these devices. This is especially true if the company has software or apps installed on it. When I worked for a Fortune 50 company, I actually refused to download company software and apps onto my personal cell phone. And when my position required me to do so on a personally owned laptop, I purchased an inexpensive secondary option that I used for those work purposes only. Now, I acknowledge that that strategy may be cost prohibitive for many of you, although for what it's worth, it will likely be a tax-deductible business expense. But regardless, make an informed decision. If you can refuse, do it. And if you can't, consider getting a second device, or at least understand that your privacy might be more compromised than you realize. All right, next, legal restrictions on employer monitoring. Now, all of that may make it sound like it's a total free-for-all, wherein employers can do whatever they want. I want both employers and employees to hear me when I say that is absolutely not the case. Employers must still comply with state and federal wiretap and eavesdropping laws. Monitoring communications without proper disclosure can lead to legal issues. In most cases, employers are required to disclose to employees what types of monitoring may occur. For example, email, internet usage, or keystrokes. And if you're an employer who believes that you have a legitimate business reason to engage in more pervasive surveillance methods, like any sort of audio or video recording, I beg you to please consult with an attorney with expertise in privacy and employment law matters. Abide by the signage and notification requirements that they suggest, and for goodness sake, please do not ever place recording devices in areas like changing rooms, restrooms, or locker rooms, no matter how good of a justification that you think you have. I shouldn't have to say this, but here we are. All right, now under the Electronic Communications Privacy Act, or the ECPA, employers are prohibited from monitoring or intercepting employees' personal communications without consent, even if the communication occurs on a company-owned device. However, The ECPA has notable exceptions for monitoring of communications that are related to the business when a legitimate business purpose exists, and also when the employee has given their consent, which typically is part of the standard paperwork during the onboarding process, at least in medium-sized and larger companies. So the bottom line is this. Employees, if you are using a work device, don't say anything or write anything, business-related or otherwise, that you wouldn't want your supervisor or the company's owner to see, read, or hear. Business owners, if you believe that surveilling your employees' electronic activities or installing cameras or other recording equipment is vital to the successful operation of your business, there are legal ways to do it, but you absolutely must consult with a lawyer to do it the right way. Even if your company just uses monitoring tools that track which websites the employee visits or which applications the employee utilizes throughout the day, check with your attorney to see whether disclosure and/or employee consent are required under current state and federal laws. Social media policies. Now, I could go on for hours about workplace privacy matters, but let's move on to talk about social media policies specifically. Employers should have clearly written social media policies that outline acceptable uses of social media during work hours or while on company devices. These policies should include details about what employees can and cannot post, particularly with respect to the company, its clients, and coworkers. It is imperative that these policies are clear and that they're applied uniformly across the company to avoid claims of discrimination or wrongful termination. If the scope and constraints of the social media policy are not clearly defined, supervisors or HR will necessarily have to exercise discretion. And what's professional judgment to one party often appears as arbitrary, capricious, or unfair to the other side. For the same reason, companies should clearly state what disciplinary actions could arise from violating social media policies, including termination. Let's move on to regulatory and industry-specific concerns. So the details of each company's social media policy are going to vary based on everything from regulatory concerns to industry norms to employer preferences and risk tolerance to company culture. I suggest that you have an employment lawyer draft your social media policy, particularly if your business is within certain highly regulated industries. For example, if you're a medical practice or an allied health services clinic, or you're in finance, law, or other professional services, your company can and arguably should enforce stricter social media policies due to stringent regulatory restrictions and other privacy concerns, like HIPAA in healthcare or FINRA in finance. Employees may be prohibited from posting any work-related content, even outside of work-related hours, in order to avoid confidentiality breaches. Some companies, again, particularly in healthcare and also education and child-focused services, may prohibit employees from interacting with clients or patients on social media in order to maintain appropriate professional boundaries. Now, this is by no means exhaustive, and again, a good employment attorney can help you discern what are appropriate and useful restrictions to impose, and also what's going too far or not far enough. Now we're going to talk about non-disparagement and confidentiality clauses. In addition to the written social media policy itself, employers can set expectations about what types of social media posts and other public communications are prohibited by incorporating non-disparagement and confidentiality clauses into your employment and independent contractor agreements. And if you're a business owner who's been watching my videos, you know that you should have legal approved forms of these agreements in place before you start hiring new staff. Non-disparagement clauses prevent employees from making negative comments about their employer, which usually means the company itself, as well as its owners, officers, and employees, and often including the goods or services the company provides, in any public forum. Now, this used to mean talking to the press or engaging in a whisper campaign in professional circles, and it still does include those things. But now the primary concern is usually posting defamatory or derogatory marks online, whether through social media posts, blogs, YouTube channels, review sites like Yelp, or otherwise. Depending on the agreement, violating these clauses could lead to termination or even legal action. A confidentiality obligation, on the other hand, means that the employee must refrain from sharing the company's confidential or proprietary information, trade secrets, or client data anywhere, including on social media, even after employment ends. Breaches can lead to serious legal consequences for the employee due to the significant harm that can result to the company if its intellectual property and information it has invested in creating and maintaining is publicly exposed. All right, now freedom of speech versus at-will employment. So far, we've mostly talked about privacy matters and social media restrictions where there is a direct nexus to the company's legitimate business interests. But what about situations where the company's legitimate business interest is simply to not be associated with an employee who is posting offensive jokes, inflammatory tirades, or who simply lacks the common sense and discretion to know that not everything needs to be shared with everyone? So employees should be aware that while they have freedom of speech in public spaces, it does not protect them from the consequences at work. In at-will employment states, employees can be, and frankly often are, terminated for their social media activity, especially if their posts negatively affect the company's image or conflict with the company's culture. The constitutional right to freedom of speech seems to confuse a lot of Americans who invoke it, but to wildly simplify it, it really just means that the government cannot swoop in and shut you up just because it doesn't like what you have to say. Now, barring some exceptions like governmental entity employees, your relationship with your employer is totally out of scope of that. But what if the government actually is also your employer? So public sector employees may have more protections for free speech under the First Amendment, but even there, these protections are not absolute, particularly if the employee's speech disrupts workplace operations or violates workplace policies. So with all that said, at-will status does not give the employer free rein to fire you for any reasons having to do with your social media posts. If you are terminated because you posted a picture of yourself outside your mosque, and that's how your Islamophobic employer learns that you're Muslim, or if you're a man who posts a picture of yourself holding hands with your boyfriend, and that's how your homophobic employer learns that you're gay, or you post a picture with your parents, and that's how your racist employer, who assumed you were white, learns that you're biracial, you get the picture. These are clear cases where your status as a member of a protected class was involved. If you believe that you were fired because of this, screenshot the post and collect any evidence that you can that supports your belief that the termination decision was based on your post and, more importantly, your protected class status. Then you need to contact an employment litigator or the EEOC. Protected social media activity. Now, invoking your free speech rights may not be the decisive argument that comment section trolls will have you believing it is, but federal and state laws do provide some additional protections. I'd like to talk about the National Labor Relations Act, or the NLRA specifically. The NLRA is primarily associated with unionized employees, but under its terms, all employees, including non-union employees, have the right to discuss work conditions, pay, and other job-related issues anywhere, including on social media. Employers cannot discipline employees for engaging in concerted activity to improve workplace conditions, again, including through something like a private Facebook group where the potential merits of unionizing are being discussed among interested staff. Employees also have a certain measure of protection from retaliation if they are discussing workplace discrimination or harassment issues on social media. Now, there is a fine line between discussing unacceptable workplace conditions and outright disparaging the employer, so both parties should proceed with caution. Employees, while making these comments, and employers if they discover them and want to pursue disciplinary action, since these types of posts may well be deemed to fall within the scope of whistleblower protections. Employee rights versus employer concerns. So as you can see, there's a tenuous balance between employee rights versus employer concerns, and technological surveillance capabilities are outpacing the law's ability to keep up. Employers need to balance their interests in protecting their brand and preventing workplace disruption with the employees' rights to express themselves outside of work. Creating policies that protect the company's legitimate business interests without overreaching into employees' personal lives is key. Employers also have a legitimate interest in ensuring that employees do not damage the company's reputation through controversial or offensive posts. However, care should be taken to ensure that disciplinary actions are not seen as infringing on lawful employee activity. So let's wrap this up with some best practices for employers. This is not easy, even for lawyers with expertise in privacy and employment matters. We have to listen diligently and think carefully about our clients' true priorities and the balance of legal and ethical behavior to strike the right balance. If you're watching this video because social media usage is becoming a concern or a distraction at your company, my best advice, as always, is to talk to your lawyer. This general educational video is not enough. But from a philosophical perspective, remember the following. Employers should be upfront about what monitoring will occur and under what circumstances. Clear communication helps build trust and avoids surprises for employees. Employee-initiated litigious situations are far more likely when the employee feels blindsided or betrayed. Providing employees with training on acceptable social media use, company policies, and potential consequences is essential. The supervisors and managers enforcing these policies also need to be trained, with an emphasis on applying the rules consistently and fairly across staff. Social media evolves quickly, and companies should regularly review and update their policies to reflect new platforms, trends, and of course, new legal developments. Okay, before I wrap up, I want to note that this video is overwhelmingly focused on employers and employees in the non-union context. Although much of this content may be applicable to unionized employees as well, union members should be aware that you may have different and oftentimes more favorable rights under your collective bargaining agreement, and companies that employ unionized workers must ensure that social media policies and enforcement mechanisms are in compliance with union rules and CBAs. If you are an aggrieved unionized employee, check with your union rep if you believe that your supervisor is overstepping. Okay, if you've made it to the end, I salute you. I appreciate your likes, and I hope you'll subscribe if you're interested in learning more about business, law, privacy, and HR matters. Please let me know in the comments what other questions you have about your rights and obligations at work, whether you are a business owner or an employee.